Court is on the record in the City of Conneaut versus Keith Garvin, 25 CRB 91. On April 7th, 2025, Mr. Garvin pled not guilty to one count of domestic violence, a first-degree misdemeanor. We conducted a first pretrial conference on April 14th, 2025. This case is set for a second pretrial conference today. In the meantime, on April 29th, 2025, the law director filed with the court a motion to revoke Mr. Garvin's bond. And so the court also, in addition to the pretrial conference today, the court also set this case for a hearing on a motion to revoke. This case was set at 9 a.m. today. The defendant was given notice of the hearing today. We have a signed receipt in the file show he was given notice at his last pretrial conference. It is now 9:16 a.m. and the defendant, Keith Garvin, has failed to appear. Present in the courtroom is his attorney, Philip Heasley, law director John Lewis, and Officer Pinkett of the Conneaut Police Department. Mr. Heasley, can you advise us to this where your client is?
Yes, Your Honor. Thank you. My client's whereabouts are currently unknown to me. I will say for the record that notice letter for him to be here today at 9 a.m. with the time and date in bold print did go out to him. And we have not heard from him, Your Honor. And furthermore, as of today, I have been provided with additional discovery regarding the alleged incident regarding the bond revocation hearing. So, unknown, Your Honor, and I'm sorry to say that. Thank you very much.
Have you attempted to reach him this morning?
I have not done that, Your Honor.
I thought you told my bailiff that you attempted to call him this morning.
Not this morning, Your Honor. So, I'm sorry if I indicated that. No, that was.
Do you have a good contact number to call him?
I will check, Your Honor.
You know, Mr. Heasley, if your client, and that happens fairly frequently, when your client fails to appear and you have contact information, you shouldn't have to wait for the court to tell you to call him.
Yes, sir.
I mean, you've been doing this long enough to know to get on the phone and call him even before we go in the courtroom. Don't even worry about it. He's not here. I'm revoking his bond. I'm issuing a warrant for his arrest. No bond will be imposed on that warrant. We'll reschedule anything in this case until the defendant is incarcerated and the warrant is executed. You know, for the benefit of your client, you may want to do that in the future, but too late now. I'm revoking his bond. I'm issuing a warrant.
And, Your Honor, I don't see a phone number in our contact information for what that for. So, on the issue, thank you. Thank you.
Anything further, Mr. Lewis?
No, Your Honor. Thank you.
Okay. This matter is concluded. I'm sorry that all the witnesses are inconvenienced. Mr. Garvin. Court's back on the record. City of Conneaut versus Keith Garvin, 25 CRB 91. Mr. Garvin comes strolling in at 9:25 a.m. Case is set for 9 a.m. Where you been? Excuse me? Home. Take him into custody, hold him, and then we'll make you think about being on time. Seriously. We're revoking your bond. Tired of people being late. I've got a full docket today. Full docket. You know you're supposed to be here at 9. Okay, the court is back on the record in City of Conneaut versus Keith Garvin for the third time. Case number 25 CRB 91. The court instructed Officer Pinkett to bring Mr. Garvin back up from the jail so we can proceed with today's hearing and pretrial conference. Mr. Garvin is present He's accompanied by his attorney, Philip Heasley, also present.
The hearing is supposed to start at 9 a.m. sharp. Judge Boyd is already on the bench. The prosecutor is prepared. The clerk is waiting, but the defendant's chair still empty. Judge Boyd checks the clock, her irritation building. This is the third time he's been late, she says, tapping her pen against the file. The entire courtroom feels the tension rising with every passing minute.
Law Director John Lewis and Officer Pinkett sitting at the law director table. Mr. Garvin, does your attorney know how to get a hold of you?
I left like 4 different voicemails.
You left him 4 different voicemails? Does he have your phone number?
Might have his contact number.
Write your phone number down. You got it?
Yes, sir.
Okay, that's good, because earlier a few minutes ago, Mr. Heasley reported he did not have contact information for you. So, when did you leave these 4 voicemail messages?
I believe the first one was the day after court.
Do you guys even have voicemail at the public defender's office?
We have voicemail, Your Honor.
I'm not even going to get into that.
Okay.
You know, if this is true, because now I'm really steaming. Why were you late today?
I thought it was at 10. I thought I was here 30 minutes early.
Yeah, well, I've got a signed receipt in the file showing that you signed a receipt with a 9 o'clock a.m. hearing date or hearing time. So you were wrong that it started at 10. Okay. Counsel, have you guys talked about possible resolution, or are you ready to proceed with the hearing on motion?
I'm ready to proceed, Your Honor.
Okay. Mr. Heasley.
Thank you, Your Honor. We have just been provided with information regarding the revocation
What do you mean just provided?
earlier this morning from the prosecutor, Your Honor.
Well, you knew this hearing. You knew today was also scheduled for a hearing on the revocation, though,
Yes,
right?
sir.
Okay. So you're talking about like discovery information?
This is on an alleged incident from April 20th.
When I ask you what were you provided today with, is it discovery information about the revocation issue?
Yes, sir.
Okay. So what are you asking?
And I do realize the court has its schedule a minute or two to speak with Mr. Garvin regarding the revocation and whether he would admit to the same. And if not, we're prepared to have a hearing. Thank you.
Okay, go ahead. Take a few minutes.
Thank you,
You
sir.
know the court's schedule today.
Yes,
I mean,
sir.
we are stacked. We're going to be
Yes,
here
sir.
until 5 o'clock tonight. So, back on the record, the City of Conneaut versus Keith Garvin, 25 CRB 91. Mr. Heasley, have you and your client had an opportunity to discuss this matter?
We have, Your Honor.
Okay.
He wishes a hearing on the revocation of bond. Thank you.
Okay, thank you. Any opening statements, counsel?
No, Your Honor.
Wait, opening.
Okay, call your first witness, Mr. Lewis.
City would call Officer Dan Pinkett. Are you a certified peace officer in the state of Ohio?
I am.
I want to draw your attention to April 28th, 2025. Were you on duty that day?
Yes, sir.
And did you have any interaction with the defendant, Keith Garvin?
Yes, sir.
Okay, and how to tell the court, please, how that interaction transpired.
Sure. I returned to the Conneaut Police Department to meet with a male subject identified as Mr. Garvin in the front lobby of the police department. Mr. Garvin proceeded to tell me that while in the vehicle with the mother of his child, Tony Martini, that she struck him several times in the face while they were going to get dog food.
Did that allegedly happen on April 28th
Yes.
in the city of Conneaut?
Yes.
He was in the vehicle with the alleged domestic violence victim, Tony Martini.
That's correct. Or he was being the victim in this case.
Told you?
Yes, sir.
Okay. What, if anything else, did Mr. Garvin tell you?
That while they were going to get dog food, he called his friend to go lock his front door. Mr. Garvin advised me that that upset Miss Martini, and she became enraged and punched him approximately, if I do recall correctly, 4 times in the face.
Did you at any time take a written statement from Mr. Garvin?
Yeah, that day, yes, sir.
On that day?
Yes.
That's a written statement that Mr. Garvin provided to you on April 28th.
Correct.
Could you please read that for the court?
Sure. Tony Martini picked me up to get dog food. Then I called my neighbor to lock my door. That's when she lost it and punched me 4 times. She busted my lip, my neck, and jaw is swollen. So I called my friend to take me to the police station. And file this report. I'm sorry.
Is that signed by Mr. Garvin?
Yes, sir.
Did you witness him signing that?
Yes, sir.
Okay. I'm going to approach again, Your Honor, and did you obtain any other evidence in the case?
Yeah, I spoke to Miss Martini afterward.
Okay. And did she provide a written statement?
She did.
Okay. Did she provide anything else to you?
Yeah, she showed me a picture of emails from Mr. Garvin to her on her phone.
I'm going to approach the witness again, Your Honor.
Okay.
Do you recognize that photograph, sir?
Yes, sir.
And did you?
20 minutes later, the door swings open, and the defendant casually strolls in, sipping a drink, earbuds in, acting like he's walking into a mall instead of a courtroom. He doesn't hurry. He doesn't apologize. He even waves at someone in the back row. Judge Boyd's eyes widen in disbelief. Sir, this is a courtroom, not your living room. The defendant shrugs, claims he overslept, and says traffic was crazy as always. The excuses fall flat instantly.
Take that photograph.
I did, yes, sir.
What's depicted in the photograph?
It's emails from Keith Garvin to Miss Martini saying, hurry up. She says in the shower. He says, pull up real quick. And he says, the door go be unlocked. I don't even want to answer anymore. And it's from Keith Garvin. You can see it.
So the emails say that they're from Mr. Garvin.
On April 28th, that's correct.
The emails are dated April 28th?
Yeah.
And you took that photograph?
I did.
Appears to be a true and accurate copy of the photograph you took?
Yes, sir.
How about this statement? Does that appear to be a true and accurate copy of the written statement that Mr. Garvin gave you?
Yes, sir.
Thank you, Officer Pinkett. I have no further questions at this time, Your Honor.
Thank you. Cross-examination.
Thank you, Judge. Officer Pinkett, you interviewed both individuals in this matter.
That's correct.
You took statements from each of them.
Yes, correct.
And not to go over your testimony just a minute ago in word-for-word detail, but Mr. Garvin came into the police station and indicated that the alleged victim had hit him.
Or the suspect of him, he being the victim, that's correct.
And that would be Tony Martini.
Martini, correct. Yes, sir.
And then later, Ms. Martini was interviewed and her statement was taken.
That's correct.
Thank you. To your knowledge, finally, Officer Pinkett, since then, to your knowledge, has there been a repeat of any incident such as this one involving contact between the two?
Not to my knowledge, sir.
Thank you. That's all, Your Honor. Thank you very much.
Thank you. Any redirect?
No, Your Honor.
Okay. Thank you, officer. Your excuse.
Yes, sir.
So, Mr. Lewis, any argument?
Thank you, Your Honor. I think it's pretty obvious that there was contact between Mr. Garvin. He had contact with Tony Martini on April 28th, as evidenced by his own written statement that he provided to law enforcement, which is signed by Mr. Garvin. He clearly had contact with Ms. Martini, contrary to this court's bond order in this case. Also, Exhibit B shows that prior to that physical contact with her, there were emails that he sent to Ms. Martini.
You mean text messages? Yeah.
I believe they're emails.
Oh, these are emails?
They're exhibited on her phone, but they're actually email correspondence. Yes.
Okay.
So I think it's obvious that the defendant had contact with Tony Martini on April 28th, contrary to the bond order of this court, which ordered him to have no contact with Tony Martini, and therefore, city would ask that Mr. Garvin's bond be revoked, and that he can take him back into custody. Thank you.
Thank you. Mr. Heasley?
Thank you, Your Honor. Just briefly in response, we heard what the officer said, and it began with my client, Mr. Garvin, reporting an alleged crime, an incident regarding the alleged victim, Ms. Martini. That may not be a defense to a no contact order, which is what is before this court today. But I think it may very well be some sort of mitigating circumstance of some kind that is up to the court to determine. And what he said in his statement was clear that she hit him. We're not there. We're not here today for that. He's aware that a no contact order is on and is still in effect, which is why we're here today. I believe they do have one child. Is that correct?
Yes.
One child together. And he's aware of, he was just taken into custody earlier today, of the consequences of violation of no contact orders. Your Honor, we would hope that his bond not be completely revoked, that he could avoid going back into jail. The original case is still, of course, on and pending. And I think that earlier this morning gave a clear indication of the fate which awaits Mr. Garvin at the hands of the court. He does work at an establishment called Castaways, and he must avoid, under whatever circumstances there are, any further contact with the alleged victim in this, Ms. Tony Martini, and that is all. Thank you very much.
Thank you. Any response to any of that, Mr. Lewis?
No, Your Honor.
So Ms. Martini didn't testify, and she's in the courtroom today. Ms. Martini? Which one is Martini? Ms. Martini, the evidence offered by Mr. Lewis through the police officer indicates that you were together with Mr. Garvin on April 28th, 2025. And the text message or email, I should say, more or less indicates that you were a willing participant in this contact.
Yes. He asked me to bring dog food, and I did. And the only way that I was able to leave, he snatched my keys out of the ignition. The only way I was able to leave was if I took him wherever he wanted to go.
Judge Boyd has officially reached her breaking point. She slams the file shut, leans forward, and unleashes the full force of her authority. She reminds him of every prior warning, every mishearing, every moment he wasted court's time. Her voice is sharp, commanding, and impossible to ignore. You don't respect this court. You don't respect your own case. And you certainly don't respect the rules. The defendant's cocky posture finally collapses as he realizes the situation has turned deadly serious.